call the first case on our docket, case number 117422, State of Kansas v. Christopher Obregon.
May it please the court, I'm Jennifer Roth. I represent Christopher Obregon, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
By way of introduction, in this case, Mr. Obregon pled no contest to 2 felony drug crimes. At the time of sentencing, the court imposed a 6-month enhancement on each of those counts under 216805G, which is a firearm enhancement special sentencing rule. At that time, Mr. Obregon had not waived his right to contest those enhancements. We appealed, and on appeal we raised the issue about the enhancement being in violation of Apprendi, which for the folks in the back, Apprendi is a 19-year-old U.S. Supreme Court opinion that says that if you're going to increase somebody's sentence beyond the maximum, anything other than a prior conviction has to be submitted to a jury and proved beyond a reasonable doubt. The Court of Appeals, in a decision that was on February 16th of last year, agreed with Mr. Obregon that these enhancements do implicate Apprendi. They agreed with Mr. Obregon that he had not waived a jury trial to those enhancements. He wasn't informed he had a right to one. And they also said that the Court of Appeals also found that the Florida prior that we also talked about on appeal was similar enough to the Kansas battery and said that it should stand. We filed a petition for review, and we are here today for 2 reasons in that petition. One is about the remedy that the Court of Appeals ordered, and the second is about this court's opinion in Wietrich and what that does to Mr. Obregon's case after the Court of Appeals decision.
Counsel, I just want to clarify one thing that you just recited. The plea agreement did recite that he agreed that this enhancement would apply, didn't it? The plea agreement itself, you're just saying there wasn't inadequate waiver of jury trial on that point?
Right, there was no mention, right, in the plea agreement, it was charged.
It was charged that way?
The enhancements. Mm-hmm. The plea agreement, and during the colloquy, he said, yeah, and during his no contest plea, that yes, he understood that these could apply, and the judge was upfront about that, explained that. What we are saying is that, and what the Court of Appeals said, is that he was never informed that he had a jury trial right to have those enhancements decided.
You used the phrase right to contest, and I thought that was a little overbroad, so I just wanted to make sure.
I can't even remember.
What's the distinction between what happens at a plea colloquy and the waiver of a right to a jury trial on this question? Because typically during a plea colloquy, the right to a jury trial is pretty, is the defendant's informed, understands what rights they're giving up, a right to have a jury decide each and every element of the offense. Typically what's the difference between that and the impact on the question before us on the enhancement?
Well,
why do you have to have 2 different jury trial waivers?
You don't necessarily have to, but the district court is required to tell the person that's going to enter a plea that they have a right to a jury trial on the issue of the enhancement, not just the guilt or the not guilty or guilt of the 2 drug crimes that he's about to plead to. Nobody ever mentions this idea that he has a right to a jury trial on the enhancements.
Is there a case that says that?
It says you have a
right to to notice of your right to a jury trial on the enhancement, as opposed to just a discussion about your right to a jury trial generally.
There is a case that I believe the Court of Appeals cited in its opinion, and it was from this court, I think I have this right, that in State v. Duncan, which is a case that's about upward departures, that that case this court dealt with whether or not Duncan had made a valid waiver of his right to a jury trial on that issue, and he was not informed of that right at his plea or at the plea agreement. So that would be one example I suppose I would cite to. And again, that was a departure, which has its own set of, has its own statutes. The thing is that the legislature here has specifically said this is not a departure. It's a special sentencing rule. But the point is Duncan stands for the idea that you have to know that you have this right to have a jury trial on your enhancement or your departure. So,
I guess I don't understand why the conviction wouldn't be vacated either if he didn't properly waive his jury trial right. Why isn't the whole thing just gone?
well, we're not arguing. The judge did talk to him about the rights that he has to a jury trial to determine whether he is guilty or not of these drug crimes. The issue that we have is that he was never informed that he had the right to those same sorts of rights to have his enhancement decided. And so our issue is with the because that piece of information never was never mentioned.
And the plea colloquy didn't cover the enhancement because wasn't there an understanding that the charges that he pled to was the ones with a firearm, so that would not be an issue, that enhancement would not be an issue. That was not described or explained, or that was why you're pleading these counts because they include a firearm?
No. In fact, what I would say is that the way it was charged, that those enhancements were in parentheses, that those were described, that's not an element, that's not actually what he was pleading to. And so, no.
I guess my point is we want these to be knowing, obviously, but
Right.
I'm just not quite certain why this wasn't knowing.
Well, nobody seemed to act like they knew that this could violate Apprendi, that people were just reading the statute for what it was and not understanding that this statute is problematic. And the other thing so my point is that when they're talking about here's all the rights you have, those are things that you would have that you're giving up when you enter your plea and saying that you accept that I'm going to convict you of these two things. Not anything about how this enhancement could go a different way, that you have a right to have a jury decide this enhancement, and that was nobody seemed to realize that.
Why doesn't that go to the validity of accepting the conviction at the outset, if you're right? Because that would, to me, mean that the court didn't properly describe the nature of the charge and the plea's consequences. And that's sort of pretty much a foundation for accepting a plea of conviction. So I don't see how you get to parse one and not the other.
Well, I guess I had not thought of it that way. It certainly
Because
is a
you're saying
consequence.
that he
It
didn't
is.
understand the plea's consequences because he didn't know he was going to get hammered with this
No, he did.
enhancement.
No, actually, he did know that. The judge did tell him that these enhancements could apply to you. And at one point, the judge even says, for the sake of argument, for the sake of this discussion, let's just assume I'm going to give you those enhancements. And so my client does understand that. And in fact, that's again, those enhancements are in the parentheses in his complaint. What was never discussed with him is that he had the right to have a jury decide just that enhancement part. And that nobody seemed to acknowledge that or know
Counselor,
it.
in the Apprendi's progeny, there are a number of cases where the state would argue something was a sentence enhancement. And the Supreme Court made it clear it's the functional equivalent of an element. And so basically here, the 6-month enhancement for firearms used in furtherance of the drug felony is the functional equivalent of an element of the enhanced crime. And we don't require the judge to tell the defendant that they have a right for the jury to decide each element of the crime with which they're charged. So we're back to my colleague's question. If this is that enhancement's the functional equivalent of an element, making him charged with the enhanced version of the crime, it's a crime that he's charged with, he pled to, he was given these rights. Why doesn't it apply to all the elements of that crime? The waiver of the jury trial is kind of where I think we're asking.
Well, I don't think that to me, it's not represented to him as an element. I just maintain that when they're advising him of his rights, they don't talk about it's not an element. They're not talking about these are your rights and this is what is going to happen at a jury trial in the context of, and then the state's going to have to prove beyond a reasonable doubt that that there was a gun and use the exact words that in furtherance of a drug felony, etc. They're talking about. I just do not think that is something he was advised of. I do not think that is at all apparent that we can even say that he could knowingly, that he would even know that to make a knowing waiver.
But what's the authority for that? I mean, it's one thing to have an opinion about the context, but what's the authority, legal authority for
I
it?
guess I'm a little bit, I guess I'm a little flummoxed because I'm thinking about these other things that talk about departures and this idea that we're going to enhance your sentence, we can enhance your sentence if we find these certain factors, but we don't say that those factors are elements that we got to explain to you during your plea. I mean, I don't understand. I guess I don't know.
Is the problem here that the judge actually gave the wrong direction to the defendant? I mean, what the judge said was, you've got these charges against you and you have the right to have a jury. So that's a question. A jury could convict you of the offense with which you pled. And your client answered yes. The very next question is, do you also believe that the court could properly make the finding that the 6-month enhancement applies for both these offenses? So here it was very specific in that the judge didn't include the jury finding in the enhancement, narrowed it to the court making the finding, and so actually gave an advice that was contrary to what the law might be, if you're correct that it was a print.
Right. Thank you. That I agree that is not the proper law. That might be what the statute says, but that is not constitutional. And that what we know and what the Court of Appeals found here was that you cannot give this gun enhancement unless the person waives their right to a jury trial and or is submitted to a jury. And so it's not legally correct to say that the court can make that finding without also saying, by the way, you also have a right to have it be determined by a jury. So I would agree that that was an incomplete statement.
If that's true, doesn't that invalidate the entire waiver? I mean, how can you bifurcate the waiver and say this part was good and this part wasn't good. It just seems to me like it's all good or it's all bad.
Well, certainly under the way that Justice Johnson has explained it, that if we're going to call this, if this is an element, then I see your point and the point that Justice Biles made too.
Would your client object to that? Having a reversal of his conviction be sent back for further proceedings?
I do not know. I cannot answer that question. There were a number of counts that were dismissed. There were, you know.
18, it was 18 other drug charges, right?
Right. There was 20 total now that I think about it. Well, I see that I'm out of time, so unless anybody has any other questions right now, I will take my seat.
Do we have any further questions? Thank you, counsel.
May it please the court. My name is Jason Oxford and I represent the Geary County Attorney's Office in this matter. I'm prepared for argument. I've been listening to the questions asked by justices to counsel, and I would agree that the firearm enhancement was discussed from top to bottom. It was in writing. It was covered by the plea agreement. It is so intertwined with the waiver of the defendant's right to a jury trial as it relates to guilt or innocence that it can't be separated. It must be covered under that particular waiver. I'm reading from the...
How can that be true, given the wording that I just read? The judge advised that it would be the court that made the finding.
I think that if you look at that, the judge's statement that the court would make the finding is acknowledging the defendant's waiver of his right to jury trial as it relates to guilt, as it relates to guilt and the firearm enhancement. And under the departure statute, that's true. The court can't accept a waiver from a defendant as it relates to having a jury make that decision on the enhancement, wherein it would default to the district court to make that decision.
But the context here seems to be the first question advises you have a right to a jury trial. And then the second question is, and you understand that the factual finding, that if you're stipulating to these facts, that's going to be enough for the court to make the finding.
I think that, I'm sorry. Jason.
Well, I just wonder if that context at least wouldn't be potentially misleading to the defendant.
I understand what the court's saying, and I would suggest that considering the written waiver, the talk about the enhancement provision from the beginning of the plea colloquy to the end, I think that it was understood. I don't think any reasonable person could not understand that that's what the court was advising the defendant of, and that's what the defendant was accepting knowingly, voluntarily, freely, and intelligently.
Counsel, I think I'm correct, but help me out, that the statute that we're talking about refers to the trier of fact making the finding, correct?
That's correct, Judge.
Is it your argument that when the judge told the defendant that the court would be able to make the factual determination that would lead to the enhancement, that the court was basically just saying, as a result of your waiver, I become the trier of fact? I mean,
That's
it sounded
my position.
like that's what you're arguing.
I apologize for interrupting, Justice Steve, but that is my position. That's what the state would be arguing.
So you're not conceding that that's an incorrect statement of the law. You're saying that the impact of the jury trial waiver is that the judge now becomes the trier of fact.
That's correct, Judge. As it relates to the departure.
Well, as it relates to the whole thing,
As it
right?
relates to the whole thing, yes, Judge.
So that begs the question that we were originally here about, which was whether you need a separate one for a sentence enhancement factor as opposed to the crime.
I'm sorry, could you
Your answer to that begs the original question, which is the fine point your opposing counsel was getting at when she first stood up, that the jury trial waiver for guilt innocence is inadequate to cover jury trial waiver for the sentencing factor.
And again, I would resort back to the kind of the conversation that the court's been having with counsel, that again, it's so intertwined with everything else that we're talking about here. I would reference in the Court of Appeals decision that in conjunction with the agreement, Obregon signed a waiver of rights that identified a trial by jury of 12 persons as one of those rights. Later on, as part of a lengthy recitation of the rights, the district court told Obregon he was entitled to a speedy and public trial by jury. And I think that, again, because there's discussion about the enhancement under 216805 G2, I'm sorry,
I know what you mean.
but you know what I mean. I'm sorry.
And your argument is the defendant knew what we meant.
And that's exactly correct, Judge.
Well, I've got a different, I approach this differently because the panel's already decided that the defendant did not validly waive his jury trial right, and you didn't cross-petition, the state didn't cross-petition for review of that, so that part's done, right? If you didn't challenge an adverse ruling from the Court of Appeals, that part's settled. So to me, the question is, what are the consequences of the Court of Appeals decision? Because what it said was, because of that, we're remanding the case for resentencing in front of a jury, which raises a special question controversy. And other panels of the Court of Appeals have said, no, you just send it back and you don't even get the enhancement because you're done. And so accepting that we can't argue about whether it was a valid jury trial waiver issue because you didn't cross-petition that. What's the state's position about why you're entitled to go back and have a jury decide the sentencing enhancement versus the other Court of Appeals decisions which have said, no, we just vacate that part of it and it goes back for resentencing without the enhancement because you're done?
Yes, and Justice Biles, thank you for explaining that, because I was not understanding the question originally, but now that you've elaborated, I guess the state's position, the appellee's position would be that I would agree that the matter cannot be remanded for a jury to consider this. I think that
You think that violates the special question principle?
I think because, and counsel has sided the court with it, it's not a departure. It's a special sentencing rule. I think that...
What are you here arguing about then? I'm confused. I may have just misunderstood.
I'm here arguing that the Court of Appeals was incorrect that in not making the finding that the jury trial waiver covered the...
Well, my colleague Justice Biles is suggesting that perhaps that issue is not preserved because you didn't cross-petition. But then I heard you just say that you essentially agree with the defendant's position that there can't be a remand.
I don't think that there could be a remand to call a jury to make that decision, and based upon
But if we are stuck, quote unquote, with the Court of Appeals opinion on the validity of the waiver because the state didn't cross-petition, and if you agree that there can't be a remand, what else is left of this case?
I'm not saying, I don't know that there necessarily cannot be a remand. I think that there is a provision in the departure statute that does talk about, as it relates to upward dispositional or durational departures, that if a state files an upward durational departure and gives the court the appropriate notice and calls a jury, and the jury hears the factual scenario, makes a decision on guilt, the court can retain that jury to hear the sentencing portion, the departure portion of the sentencing.
And what's that got to do with anything?
Because the court can, there's a provision within that subsection that talks about if there's a later time that the court
Right.
wants to convene.
And it's
that.
talking about a departure.
It's talking about a departure.
And you just conceded that this is not a departure.
Maybe I'm not conceding that anymore.
Well, the statute says it's not a departure, and so, and we've said, for the most part, there's some exceptions, but we've said pretty often that sentencing is purely a matter of statute. And in fact, when we had the departure, had Gould, there was a court that set up its own way of having a jury decide the enhancement, and that court was reversed because there was no statutory scheme that would authorize it. And so I guess that's a long way to get to my question of what would be the authority of the district court to devise its own scheme for calling a jury and having a trial on the enhancement. It would have to be something that was manufactured by the district court, right? Because there's no statute.
Other than the mandate of the Court of Appeals telling it to do so.
Can you address the preservation question directly? Do you think that the Court of Appeals decision that there was a problem with the waiver is properly in front of this court?
Yes, Judge.
And how? How do we get there?
And I apologize, Judge. I was not anticipating that discussion, but I think because the appellant has petitioned the Court of Appeals and has addressed that issue, that it's before the Supreme Court, and the court can hear it.
Let me move you over to the other. There are two issues in this case.
Right.
And we kind of jumped on the second issue about the jury trial waiver for the reasons that have been discussed here. My question had to do with why are we remanding for resentencing and all that? Why don't we just vacate the whole conviction? But the other question is how to score the Florida battery conviction. And during the pendency of this matter, we decided the Wetridge case. You haven't filed anything that indicates one way or the other whether Wetridge should apply. So let me just ask you, is the state's position that Wetridge can now apply to this case?
Judge, I think that it probably can, and I'm prepared to argue that as it relates to.
Do you want? I don't think you want it to.
I don't necessarily want it to. I just.
Okay.
Right.
I mean, you know, we're.
In saying you don't want it to, then you agree that the Florida statute is broader than the Kansas statute?
No, I do not.
Okay, well then explain why that's the case.
Okay, so the appellant uses a hypothetical as it relates. First off,
Well, why don't you go to just the language of the statute?
Yeah, the appellant is not contending this is not a felony, just that it's not a person felony. The defendant's not contending that the bodily harm variety of battery in Kansas is any different than the bodily harm variety of the Florida statute. The language of the statute, I think, if you look at the Florida statute, relates to the physical touching of an individual against that individual's will.
Correct.
Comparing
against the person's will.
Comparing to the touching in Kansas in a rude insulting, or angry manner. And I would argue that it's impossible. I think it's an identical statute, and this is why. I think it's impossible for a person to intentionally touch someone in the manner prescribed by the hypothetical that the appellant gives to the court against that person's will, without knowing that person, without there being some consent, without there being some prior advisory. I'm saying that it's probably typical. In order to prove that in Florida, in a Florida court, I'm guessing that a prosecutor would have to present evidence that a person touched another person in a manner so recognized by society to not be a welcome touching, such as being touched in a rude manner or an insulting manner. In the hypothetical given, there's this hugging, and it should be recognized that this is a show of comforting. Obviously, if the same person is at the same funeral and throws a piece of paper or throws a cup at the widow, that's going to be perceived to not be pursuant to that person's will, the victim's will. So I would say that it's essentially identical, Judge.
But isn't the problem here that the Florida statute has two provisions in it, and one is in fact broader than the other, and we don't know which offense Obregon committed in Florida because the state, I don't mean to be picking on you, the state neither the pre-sentencing investigation or the state proved which of the two alternative paths that Florida can use for that conviction was the one that Obregon committed. I mean, is there somewhere in the record? It's not in the pre-sentencing investigation report. So how do we know? And we don't.
The only way to for sure know would be to remand back and have that sentencing hearing again, and allow the state to present to the court evidence of, maybe in the form of a complaint from Florida, of the legal description of the offense.
And you would agree the state has that burden to prove?
At any sentencing hearing, yes, I think that the state has that burden.
I'd like to return to your comment that, as I understand it, despite the language of a Florida statute, common sense or case law from Florida would indicate that there has to be more than just this actually and intentionally touching against their will.
What I was saying is, I think in order to prove that, I mean, I'm trying to think of it in a practical matter, in order to prove that someone touched another person against their will, without having any prior conversation, knowledge of not wanting to be touched, that the only way that you could ever prove that someone touched another person against their will would be to prove that they did so in a manner so recognized by society as to not be acceptable, to be rude, to be insulting.
So how would we make that determination? Or how would a Kansas court make that determination despite what the Florida statute's language says? Or is the court supposed to be looking at Florida case law or trial transcripts or what?
I suppose the court could, and I think that I also think that the court can look at Kansas law and you know, the burden of proof and the legal obligations of the state in trying to prove a case of battery in the state of Kansas.
Sorry.
I was going to say, Kansas requires more under its statute than Florida statute does on its face, does it not?
Again, my position is that it doesn't necessarily require more, because I think that in order to prove, practically speaking, in order to prove that same offense in the state of Florida, absent a showing of consent or non-consent by the victim, you would have to be presenting facts that someone was touched in a manner that was insulting, that was rude for someone not to accept the touching.
So the facts in Florida a prosecutor have to prove would be that the touching was done in a rude, insulting, or angry manner?
I think as a practical matter, that's what they would have to prove at the trial.
All right. Justice Stiegel, you had a question?
Just gonna, I understand from your answers that you don't have a Florida case that says that.
That's correct, Judge.
We've taken a lot of your time with our questions. Would you like 30 seconds or less to wrap up, or do you think you've made your points?
I think I've made my point. I thank you for that.
Do we have any further questions? All right. Thank you, counsel.
Just a few points to close. First of all, I just apologize for being somewhat speechless. I was sort of going at this case from where the Court of Appeals had left it. And because, as has been pointed out, the state hadn't cross-petitioned or made any additional arguments, I mostly came here prepared to argue about how you can't remand it and why. So I'm sorry I didn't foresee that this court was looking at this more broadly and a little bit differently. But I still maintain that this court's own opinions have made clear that waiving a jury trial is not effectively also waiving your right to have a jury decide something that's going to enhance your sentence. I believe that's what you say in Horn. I believe that's what you say in Duncan. So I maintain that when my client was not informed about this specifically, this consequence specifically, that means his waiver was not knowingly made. And of course, this, as Justice Johnson pointed out, when he was talking to the state, this court has repeatedly held that you will not work around a flawed sentencing scheme, and that the district, and I think as the state seemed to maybe concede, that there's nothing to be done about it now because there is no scheme that would apply here if this case was remanded. At the end of the day, what I'm asking this court to do is to issue an order that says that my clients should be sentenced without the enhancements, and then as with regard to issue 2, that this case be remanded so that the state can try to prove which subsection my client was convicted under in his Florida battery, and if they cannot prove with constitutionally permitted documents or other sources that in fact is identical or narrower, then my client should be resentenced as though that Florida battery was a non-person felony.
Any further presentation?
No, thank you.
Do we have any more questions? Thank you, counsel.
Thanks.
Thank you both for your arguments this morning. Court will take this matter under advisement.